Welcome to the Same Day Podcast, where we discuss driving incremental business growth and other topics related to real estate, property management, and entrepreneurship. Now, to the show at hand.
Hello there, Yoni Schmidt here, hosting today's episode of the Same Day Podcast, where we connect with top real estate, top business entrepreneurs, and leaders. Past guests include Chip Gabrino, a local restaurateur entrepreneur, Elliot Nelson, the CEO of the McNelly's Group, and Morgan Martin of Merrill Lynch. Today's episode is brought to you by Keyrenter Property Management. We are a full-service property management company helping our clients buy, renovate, and operate real estate assets. We help our clients build wealth while taking the headache out of property management. That is why no matter what rental you have, single-family homes, condos, townhouses, apartments, we have the management solutions that you need. Go to KeyrenterPMC.com or email us at info@KeyrenterPMC.com for more information. Today, I'm excited to welcome Ben Aussenberg, an accomplished family law attorney and partner at Aycock Aussenberg. Ben is dedicated to providing clients with the highest level of legal support during some of life's most challenging moments. With expertise in child custody, asset division, prenuptial agreements, and much more, Ben brings a wealth of knowledge to today's conversation. In this episode, we'll explore the intersection of family law and real estate investments, and specifically how individuals and couples can protect their assets and what the best options are for managing investment properties during and after a divorce. Welcome to the show, Ben, and thank you for being here.
Hey, Yoni, good morning. Thanks for having me.
Yeah, so nice to have you. Ben, let's dive right in and talk a little bit about the foundations of family law and real estate. You have a lot of experience in this field. I've known you, I guess, for maybe a decade now. You were in Colorado doing this. You moved to Tulsa, Oklahoma, and now you're based here. Tell us about, your experience and what are some of the most common issues that you see when that arise when, real estate investments are involved in divorce proceedings.
Sure, thanks. So a little bit about me. I've been practicing law for about 11 years, just under 11 years. Exclusively in the family law area. Spent kind of my high school and college days clerking and working at different family law firms in Atlanta and Houston and Colorado. I moved to Colorado after law school in that would have been 2014. Moved to Colorado, worked there for 6 years, and I've been practicing in Oklahoma for about 5 years now. So been doing it a long time. I've kind of seen a lot. Both in Colorado and Oklahoma as it relates to family law. So I have a lot of experience in the courtroom. I've tried hundreds of cases through all stages of the process. In terms of, kind of the most common issues that I see, it kind of depends on where you are in the case. Are we at the beginning or middle of the case? Or are we, kind of at the end of the case, or is the case over? So if we're in the middle of the case and we have, a real estate property, say it's a rental property. Things to consider or common issues that we see is, do we have a tenant in the property? Is the tenant going to stay in the property during the divorce? Is the tenant going to stay in the property after the divorce? Are we kicking the tenant out? When is the lease up? Is the lease priced appropriately? Oftentimes spouses will get into debates over, whether $1,500 is too high or low, or, do we need to bump it up to $2,000 to keep up with market forces? Do we want to extend the lease? Or do we want to, terminate the lease, kind of at the conclusion of its term? Oftentimes one party needs to move into the real estate property. So sometimes we'll have, kind of the main marital residence, and they'll have, one rental property, and sometimes they need it to move into, whether or not that they have kids, sometimes they need a place to go, if they're not going to be living together. What are we doing with the property? Are we selling it? Are we keeping it? So those are questions that arise and are issues that really need to be addressed during the case. Some other things include payment of upkeep of the house. What happens if something goes wrong? What happens if the AC goes out? What happens if there's a plumbing issue? So just kind of general maintaining the property. Who's paying for it? So, my advice on that is, be very specific in your orders. so that's crystal clear as to, who's responsible for what. When the case is over, for instance, oftentimes we'll need to sign deeds. So a quitclaim deed is a tool that we use to transfer all of the property interest from one party to the other party. We have to get the other side to sign it. We have to get their cooperation. Oftentimes when there's a rental involved, we've got security deposits. So if one party was the one that was handling the security deposits, they may have it in their own separate bank account, but the property is going over to the other person. And so oftentimes there's a couple $1,000s that's, kind of in flux that needs to be addressed. So we've got to handle, getting the security deposits back over to the right person. And then even after the divorce is over, we need to be clear. We got to make sure that we're clear as to who's responsible for what in terms of maintaining the house, when. So oftentimes we'll settle at mediation, but the divorce isn't going to be finalized for another few weeks or few months. And so what happens in that interim time period? If we resolve it today in December, we may not be done till February. So who's making those payments when something goes wrong, at Christmas or New Year's or in January? So those are kind of common issues that we see. We're kind of in the business of worst case scenarios. So we try our best to foresee those issues on the front end and address those before they come up.
Yeah. Awesome. That's all great information to have. And I guess how often do you see, digressing a little bit, how often do you see that a rental property is kept after a divorce and, a couple that has separated, continues to operate the asset as an investment? Is that common? Is it uncommon? I guess it would take some sort of, good relationships there between the couple.
Definitely. And it just kind of depends on what their circumstances are, what their situation is. What their goals are.
Yeah.
Can I afford a rental property? Do I want to have the headaches that may be associated with the rental property? Obviously, having a property management company such as Keyrenter come in, could be very helpful. So that might alleviate some of the headaches. But those are some of the things to consider.
Yeah.
So
Possible.
what's that?
It's possible.
Absolutely.
Not out of the realm of impossible.
Right. And what's the rest of the marital estate look like? If you're only receiving, a rental property, does that make a lot of sense? Rental properties can always be sold. And so if you're in need of cash, or liquid or semi-liquid assets, maybe it's best to sell it. So just kind of on a case-by-case basis, do you have 4 rental properties? If you have 4 rental properties, maybe you keep 1, sell 3, or the other way around. Sell 1, keep 3.
Yeah, all good stuff. Let's talk a little bit about prenups, which I know you are experienced with. How important are prenuptial or postnuptial agreements when it comes to protecting real estate assets?
Sure. That's a good question. They can be very important. It just kind of depends on where you are at financially, kind of moving into a marriage. So I think it gets a little taken out of context just in society that people think that they have to have a prenup going into every marriage, and I don't think that's the case. But oftentimes, if it's your second or third marriage, and you've kind of built up some assets and net worth along the way, it can be very important for your case. So the important part, the important aspect of a prenup is you're really going to spell out and sort of predetermine what property is going to be separate property and kept by you in the event of a divorce. And that's all it is you're saying, hey, we're getting married, we're entering into this this contract, this love contract, and in the event of a divorce, this is what happens. So it's certainly not required, but it is advisable if you have any kind of assets, especially a rental property or just real property in general going into the marriage. So the general rule in Oklahoma, as I always say, is property owned prior to the marriage is going to remain your separate property. So the court cannot divest you of that property that you own prior to the marriage. And that's going to include any passive gains or passive increases in the value of that property. So if it's worth $200,000 at the time of marriage and $400,000 at the time of divorce, that $200,000 of gain is going to be market force. It's going to be related to market forces, and that will remain your separate property. Gets a little tricky when we're talking about improvements to property. So during the marriage, you add a kitchen or you add a fourth bedroom, something like that. That gets a little bit tricky depending on how it's paid for. So in other words, if you're using marital funds, if you're using joint money and putting it into a separate property asset, it gets a little tricky when you're dealing with that at a divorce. But with a prenup, absent anything specific, that is your separate property. It's not going to say anything. It might say something about, what happens if you make improvements to it. But I've seen a lot of prenups that don't mention anything about that. And that party, it could be out of luck. It's sort of a windfall for the party that owned the property, that despite the fact that they put joint money into it, the person that had the property prior to the marriage gets to keep all of those improvements. Another thing that could come up is making mortgage payments towards a separate property house. So if there's a prenup, if it's sort of silent on using joint funds to pay that that separate property, rather, same thing. The person that had that property prior to the marriage is probably going to receive somewhat of a windfall. In the absence of a prenup, however, you'd have a pretty good argument to say, hey, we use these joint funds to pay for this separate asset of the other party. So I need some of that money back. Now, is it dollar for dollar? No, probably not. But the principal pay down, so every month you pay the mortgage, so there's going to be a pay down of the principal. And that principal pay down, you're going to have a pretty good argument for reimbursement of some of that. Again, not dollar for dollar, but 50 to 75%, you'd have a pretty good shot at getting some of it back.
Yeah. Interesting. Okay. Can you tell us a little bit about how state laws, such as those governing that community property that you're mentioning, or equitable distributions, impact the division of investment properties during the divorce? I mean, you kind of touched on this or alluded to it a moment ago. What does that look like in real life?
Sure. So Oklahoma follows an equitable division of property. So what does equitable mean? It could be 50-50, it could be 60-40, it could be 70-30, it just depends. And when we're talking about an equitable division, we're talking about marital property. So I touched briefly about the separate property. So separate property is anything acquired prior to the marriage. And then marital property is going to be anything acquired during the marriage, unless it's acquired by gift or inheritance. So there's a couple exceptions to that rule. So it really just depends on whether it's separate or marital. Was it owned prior to the marriage? Was it owned after the marriage? And that's how Oklahoma's going to look at it. If it's marital, it's subject to division. If it's separate, it's not. So we're looking at close to 50-50, but there could be circumstances which would require more than a 50% division.
The nuances, like, improving a property, a rental property, and, renovating it with marital funds, then it becomes like a little more nuanced and complicated.
Becomes more nuanced, and you have to keep in mind, you have to look at kind of the overall picture. There's going to be, oftentimes there's retirement accounts involved, investment accounts involved, cash accounts involved, other personal property involved that has value. So when you look at the overall picture, that's kind of what you're looking at is getting close to 50-50, but it has to be equitable. It doesn't have to be equal.
Yeah. Let's talk a little bit about protecting real estate investments, right? What should individuals take into consideration before purchasing real estate with a spouse or partner to safeguard investments?
Sure. There are certainly tools that can be used. I don't do real estate law, so there might be tools that I'm just not aware of or don't use very often. But what I see the most would be an LLC or a trust. Those hold the property, kind of separate and out of their individual names. This would be used for, say, tax purposes or just kind of general liability purposes. So with an LLC, if an LLC owns the real estate, they'll create. I see parties will create like a partnership agreement or even an operating agreement, and it kind of spells out what the specific rights and responsibilities are as you of the owners of the LLC. With trusts, there's actually a trust related to real estate that you could use. It's called a Q-tip. I don't do a ton of those, but I have seen them. Those are I wouldn't draft that, but I would send that out to a real estate attorney. Q-tip, it stands for qualified terminal interest property. And so you would use this, you could use it with the first spouse or sometimes with the second spouse. If you were to pass away, so you would own it jointly. And if one person were to pass away, there wouldn't be a whole lot of change after that person passed away. So the other person would kind of have what's called a life estate. So basically use of it for life. And then that trust would have a beneficiary or multiple beneficiaries. So say children or grandchildren. So when both of those principles of that trust passed away, it would go to the beneficiaries. And there's different tax benefits that are associated with that. So basically you're deferring capital gain taxes by having a Q-tip trust. And then when we're talking about divorce, we're looking to see, when that trust, when that LLC was established. Was it established during the marriage or after the marriage? If it was done during the marriage, no real question about that. I've seen people try to create an LLC during the marriage and put it in just their name. And then when it came to the divorce, they would try to say, well, it's only in my name, so it's all mine. That's not how it works. You can call it however you want, but if it was done during the marriage and it was, marital funds that was used to purchase that property, it's going to be marital property no matter what. So those are kind of ways to protect real estate when you're getting into a marital relationship.
Yeah, the Q-tip trust, I guess, would also help individuals avoid having the property go into probate. I'm guessing at the time of one of the people in the relationship or in the marriage
Absolutely.
passing. Yeah,
Absolutely. It was an automatic transfer.
Yeah, got it. Beautiful. Moving on here to some of my questions. What other specific types of agreements or contracts? I guess you kind of touched on that. Should couples have in place when co-owning investment properties? You mentioned the Q-tips. You mentioned LLCs. Anything else in mind?
Sure. So, other than that, we're really talking about what's set forth in the decree of dissolution of marriage. So once the divorce is finalized, that's going to be your final contract, and it's called a decree of dissolution of marriage. It could be by agreement or it could be by court order if there's no agreement and it goes to trial. The reality is most cases, over 80% of cases settle outside of court. So we do mostly agreed decrees of dissolution of marriage. But that's going to be the contract you look to. That's going to spell out specifically, what's to be followed for the ownership of property. And it can also be done if it's done by agreement. We put together confidential property settlement agreements. So we'll put together, we'll spell out in a contract, and it's enforceable and signed by the judge, who's keeping what and who's responsible for what. And we keep an original with us. Basically, everybody has an original, but that doesn't get filed of record, and so remains out of public view. So that's an option as well.
Yeah. And what happens when one of the parties is not fulfilling their obligation based on that final contract, right? I mean, the judge says, okay, you can have this property. You're going to be responsible for it. AC goes out. They say, I'm not going to fix it. I don't have the money. I don't care, whatnot. This was my wife's tenant. It's her cousin, whatever it is, right? What happens in those cases?
Yeah, so it depends on if it's co-owned or if it's assigned to one person. So let's say it's co-owned. There are enforcement mechanisms. So contempt of court is kind of the big one. You file a contempt of court saying that there's a valid court order. They had knowledge of the court order. They had the ability to comply with the court order, and they failed to comply with the court order. So that comes with up to a $500 fine, up to 6 months in jail, plus the enforcement. That they have to actually follow through with what they were supposed to do. So that's pretty extreme, and most people don't go to jail over it. However, it is an enforcement mechanism. That's probably the most common enforcement mechanism. If it's owned by one party and they're not, upholding their end of the bargain, usually it just falls on them. As long as it's not, we always have indemnification clauses in there. So in other words, if there's an outstanding loan or something like that, a credit card debt that they're supposed to be paying associated with the property. So if they had to, put an AC unit on a credit card or something like that, and they're not following through, we do have either contempt or enforcement actions on that under an indemnification clause.
Yeah. And for those of us who are listening and, don't understand the legal terminology, the indemnification is basically a release of liability for the other party, is what I'm understanding, correct?
Yeah, exactly.
Yeah. Yeah. So if someone needs to make loan payments on a mortgage and they fail to do so, then in the final contract and the decree or the dissolution of the marriage, that property was basically awarded to one party and they failed to make those loan payments, even if both names were on the loan, the other party that had their name on the loan is indemnified from any, I guess, foreclosure proceedings that may arise in the future from the failure to pay the mortgage.
That's correct.
Okay. Makes
That's
sense.
correct. So doesn't mean that you're not going to be sued, because I've seen that happen. Doesn't mean you're not going to be pursued or that they're not going to send it to collections, but you do have that enforcement mechanism in place.
So tell me, just kind of going down this rabbit hole, for the party who was released of the obligation to pay the mortgage because their name is no longer associated with that property, in the event that the responsible party no longer makes mortgage payments, right, and you do get sued, what protection mechanisms are there? Do you take out the decree and dissolution of marriage and you go to the lender and you say, look, here, this basically states that the responsibility falls on this other party and release this claim against me?
So it depends on the lender. Most lenders, in my experience, say, hey, your name is on it. We don't care what your contract says. You can go recoup that from the other side. And so that's kind of the most common thing that happens. Sometimes if you call up the lender and kind of get ahead of it, they'll, be proactive, because it costs them time and money. They don't want to be messing with it either. So if they know that you're going through a divorce and you're getting worked out through the court, oftentimes it kind of buys you a couple months with the lender before they start taking action. So that's how I handle it typically.
Yeah, interesting. Any other ways to protect yourself aside for, I guess, calling the lender or recouping the funds from the other party?
I mean, if you don't want your credit to be dinged, sometimes you could just pay it. Even though you don't want to pay it, you just pay it and then pursue against the other side. Oftentimes we'll put in provisions that say, if you don't, so say your name is on the loan, but the property is going to the other person. We say that if you don't refinance it or otherwise remove your name within a certain period of time, house gets sold.
Got it. Yeah, that's a great way to protect yourself.
Yep.
Tell me, I'm going to move ahead here a little bit. What are common mistakes that you've seen some people make when handling real estate, during divorce?
Not being specific enough. So you want to make sure that your court order is very specific in terms of what who's getting what, and who's responsible for what. Um, One thing is, you kind of have to look at your financial situation. So you don't want to, you don't want to be responsible for a loan that you really can't afford.
Hmm.
So I see that as a common mistake, that people are kind of house poor. That
Hmm.
was a big issue when I lived in Colorado, for instance, when the real estate just skyrocketed in value. Say a parent wanted to maintain the house for the consistency of the children, which is great. But there has to be a corresponding buyout to the other side.
Hmm.
So you may be keeping the real estate, but if there's a few $100,000 of equity, that has to go to the other side somehow.
Hmm.
Best case scenario, there's other assets that can be offset by the equity, and you don't have to come out of pocket. But some people have to refinance, and sometimes you're refinancing for a higher interest rate. So then you're paying a lot more money for the same thing.
Hmm.
I think that's a big financial mistake. 2023, 2024 was really hard here in Oklahoma and everywhere else, but I was here in Oklahoma when that happened.
Hmm.
Is, what happens when you have a 3.25 interest rate, and then here you have to refinance it at 6, 7, 8%.
Hmm.
That's a mistake that people made. And that's
Hmm.
that's ultimately it comes down to that person and that party of what makes sense for them. But you might be paying $1,000 a month more for the same thing, to refinance it to get the name of the other party off.
Yeah.
So that's kind of a big mistake.
Yeah. Interesting. Um, okay. I guess what are some other warning signs that couples should, consult with a family law attorney before making, significant real estate investments? Is it you can't really sign a prenup before you get married. I guess you'd sign a postnup, right? Or
Prenup,
no,
prenup prior to the marriage,
right?
postnup after the marriage.
Postnup after the marriage. Yeah.
Yeah. So, if we're talking warning signs, I mean that says to me, hey, maybe divorce is a possibility, or maybe a divorce is on the horizon. I think that's when you would consult an attorney. For instance, we charge a small consultation fee, and I say, it doesn't matter if you hire me or somebody else. It's worth that 1-2 hour consultation,
Hmm.
just to see where you are with your financial circumstances and your position, with respect to real estate. Are we just talking about the marital residence, or do we have multiple rental properties?
Hmm.
That's the best time to consult with an attorney, just to get the information. So even if you don't go through a divorce, you're at least armed with that information, so that it can maybe help you and your spouse moving
Hmm.
forward. Because we're not here to tell you that you should be getting divorced. We're here to help you. And so if your ultimate goal is not to get divorced, we'll help you as best we can. We can't necessarily give financial advice or tax advice,
Hmm.
but we can put you in touch with the right person. Um,
Yeah.
and so if divorce is a possibility, or you think it might be on the horizon, or the other side has brought it up, um, that's what you would do. Consult with an attorney, um, just so you don't run into any issues that could have been avoided easily.
Yeah. Okay. And I guess finally, what advice would you give anyone who's navigating divorce while owning real estate to ensure that, they're making these informed decisions? I know that, it can be an uncomfortable topic of discussion, but it happens. And, I guess let's arm the people with the knowledge, right?
Yeah, and it needs to be discussed. Whether ideally it would be discussed between spouses. Sometimes it will have to be discussed between the attorneys. But kind of getting out ahead and talking about it, is the right thing to do. Because when you're talking about real estate, it's a little bit trickier dealing with real estate than dealing with a checking account with a few $1,000s in it. Let's say,
Hmm.
there are things that take time. So if we're, renting it, it takes time. If we're selling it, it takes time. So getting out ahead, and having those conversations kind of early and often, would be my advice. No two cases are really the same. So the issues and complexities for one case are going to be different than the issues and circumstances in another case. So speaking with an attorney or speaking with your spouse and making sure you're on the same page, or even if you're not on the same page, what's our plan moving forward? As long as there's some plan, that's going to be the best advice. When navigating a divorce, when we're talking about real estate. But yeah, speak with your attorney, speak with your spouse. If a lot of people have, friends or family that are real estate agents. I talk to real estate agents all the time, even as the attorney. So they're oftentimes helpful resources. So that's what I would do, is just keep those lines of communication open.
Yeah. Ben, this has been enlightening and very informative. I do remember one time when you really helped me out. There was a prospective client that was going through a divorce, and that prospective client had a spouse that was deployed overseas, and they told me that they were awarded the house right in the decree, and I sent it to you, and you kind of looked it over and you said, Yoni, there's nothing in here that actually says that they were awarded the house. So if you get involved here as a property manager and you take on this property, you may find yourself in a precarious situation in 3, 6, 9, 12 months, who knows, whenever that other spouse returns from their deployment. So I can't tell you enough how much I appreciate that. If you're looking for advice in the family law world, you need a prenup, you have any questions for Ben, feel free to reach out. We'll make sure that his contact information is available. Ben Aussenberg from Aycock Aussenberg, family law attorneys here in Tulsa, Oklahoma. Ben, thank you so much for being here, educating me, educating our audience, and enlightening us.
Of course, Yanni, it was nice speaking with you.
Likewise.
Thanks for listening to the Same Day Podcast. Tune in to a new show each week and be sure to subscribe to get future episodes.